I thought I'd come on to make an update video to explain a little bit more about the significance of my recent posts in relation to the CPS yesterday failing to comply with a court order direction from the magistrates court. Now I'm going to go back to the beginning so you've got a full picture and understanding of what's going on. Sheena Williams from Plains Avenue in Maidstone owned her house outright and was in dispute with the council over council tax. I won't go too much details of the merits of it, but she attempted to pay the council tax and they stopped her from doing so and then made her bankrupt for it and then come after the properties. Her and her family was unlawfully illegally evicted from the property without any instrument that granted any authority for violence to secure entry, as they always do. So she then became a displaced occupier. She then took the property back, and then you've seen in the video in my blog post where the police come around and assisted Scott Hines and his merry men use violence to secure entry, and the police said it was a civil matter, again with no authority to do so. She was stage 4 terminally ill, bedridden, bedbound, and they dragged her out of the house, out of her bed, out the stairs, threw her out on the street. She only contacted me and asked me to help her get back into her property. Gave me all the details, showed me that she was unlawfully illegally evicted. There was no evidence that they had the right to remove her, so we assisted and stepped up. Now in the video you can see me cutting through a chain that was wrapped around the gate while security was inside her house. I don't deny that. The video's there to prove it. I cut through that chain. That chain was Sheena's. She told me it was her chain. The padlock is allegedly belonging to Goldstein, the trustee in bankruptcy, the guy who facilitates the theft and disposal of property for Maidstone Borough Council. He allegedly put a claim in to say that I've caused criminal damage to his £50 padlock. In the witness statement and the evidence support bundle, there's no invoice or receipt to show that he owned the padlock. There is something in the witness statement that says that I've caused that much damage to his property, the padlock, that it's irreparable and that he's had sleepless nights since he saw the video. So that's what I've been charged with. Criminal damage to a padlock with no evidence that I've caused criminal damage to the padlock. So that's gone to court, and as you know, the police used that trumped up allegation to assist the bailiffs to come and steal my property on the 17th of January 2025. So there's a lot based on this charge, because the police can't not have this charge go through, because this is the foundation of not only the theft of my property but also the criminal charges for burglary, gun equipped, and criminal damage when I took the property back on the 11th of March with a couple of friends. So we'll go back to the first hearing in the magistrates court, where it was listed for a hearing to answer to the charge of criminal damage to the padlock. I filed an application to dismiss the proceedings as an abuse of process because there was no case to answer. I attended the hearing, spoke to the district judge. The witness statement of the John Sheena's partner, the judge come out and said, I've read the witness statement from John Hicks and you had lawful excuse to do what you did. I said, I know. That's why there's no case to answer. And he said, well, you need to file and not guilty. And I said, no, I don't. I said, because there's no case to answer. I'm not entering a plea to something where there's no case. You've just stated I had lawful excuse. And he said, well, I'm going to enter a plea for you. I said, well, if you're going to enter a plea for me, I said, I'm going to elect it to go to Crown Court. To which he said, no, you can't do that. I said, why? He said, because it's a summary only offence. I said, excellent. That's even more reason why there's no case to answer. Because it's statute barred. The alleged offence took place on the 16th of March 2024. I didn't get arrested until 17th of January 2025, 10 months later. Out of time, statute barred over 6 months. I said, in any event, the CPS haven't provided any of the prosecution material, so how could I even make an informed decision on entering a plea when I haven't seen any of the prosecution evidence? I've filed an application to dismiss the proceedings which are before the court, and the CPS need to respond to it. So he said that I'm going to order that the CPS, that you file your application for dismiss within 4 weeks. The CPS have got 4 weeks to respond, and that'll be adjourned for another hearing. I said, I don't need 4 weeks. Everything I need to say is in the application which I put before the court this morning, which needs to be responded to. Well, I'm going to give them 4 weeks anyway. So he adjourned it, went to the next hearing, The judge then said, I said, well, the CPS have failed to comply with the court's order. They haven't responded to my application for dismissal. And also, the previous judge said that there was no case, that he agreed that there was no case to answer because I had lawful excuse to do what I did. This judge, District Judge Luxford, said that judge got it wrong. So she undermined what the previous judge said anyway. It's neither here nor there. The whole thing's a load of bollocks anyway. So let's play the game. So she said the CPS aren't ready, and she ordered the CPS to respond to my application to dismiss. And obviously for my skeleton argument to be put in. My skeleton argument was put in. They still haven't responded, and it was adjourned until the 12th of May. Bearing in mind it's going back to January last year. Over a year now this is taking. So 3 adjournments. So prior to the hearing on the 12th, on the 2nd of February this year, the court judge ordered that the CPS respond to my dismissal application and provide a skeleton argument to me by 4 PM on the 27th of February. Well, that was yesterday, and it's the 3rd bite at the cherry the CPS have had from directions and orders from the court to respond to a dismissal application. 3 times I've failed. I'm just a litigating person. If I've been directed or given an order to comply with by the court, by the judge, and I failed, guess what? Bit of bench warrant, contempt of court, banged up overnight, all manner of shit. But no, the CPS get away with murder because we're all in bed with each other. So my thoughts, my conclusion on this is that the CPS know that there's no grounds, it's not in the public interest, because I had lawful excuse to do what I did. The arrest by the police and the collusion and conspiracy and the way they've come to arrest me for the alleged offence, which they should have invited me down to the police station for a voluntary interview. They've been in communication with me since July 24, since the bailiffs was going to attend my property. And if you remember, in September, October, the police emailed me to say there's no need for a meeting because they wasn't in communication with the bailiffs anymore. And then lo and behold, 3 months later, Operation Zloty, 120 of them turn up at 6 o'clock in the morning in a petrol car and violently evict me from my house unlawfully without the authority to do so. Which is all going to have to come out in court. So the basis of this is the arrest for the padlock that I had a lawful excuse to cut because I was invited and there was a displaced residential occupier, as confirmed by the district judge in the first hearing, it's going to collapse. It's not going to go anywhere. But the problem is, once the CPS capitulate and agree that there is no prospect of success to get a prosecution against me for the criminal damage of the padlock, the whole world falls apart. Because that means there'll be false arrest, false imprisonment, kidnap, unlawful detention, etc., etc., for when they come and violently took me out of my house to assist the bailiffs. So if that arrest gets proven as being unwarranted, then that means I was illegally removed from my property, which means the possession was unlawful, which means that the criminal charges in the Crown Court for burglary is going to collapse, because if I should have never been removed from the property in the first place because the police have assisted them, then I can't get charged for, or we can't get charged for burglary, criminal damage and what is it? Yeah, not aggravated trespass. What's the charges? Criminal damage, attempted burglary, and going to quit. That's it. They're all going to fall apart. So I'll keep you up to date. We'll see what the CPS come back with. But they've got to provide a skeleton argument. Someone's got to put their name to that. Someone's got to respond to all of the points that I've made as to the reason and grounds why the prosecution shouldn't go ahead. There's no prospect of success to get a charge. It's not in the public interest. There's no evidence of I've even caused any damage to the padlock. There's evidence I cut the chain. There's evidence of someone in the video. You can see it. Someone saying take the padlock away. So how can Goldstein claim that I've caused irreparable damage to his padlock without any proof of ownership of this padlock, that this padlock was even his? Where's the evidence? This is a fabricated, conspired, colluded attack by the police to put a charge on me, to have a reason to come around and assist the bailiffs. And that was also proven, not sure, I nearly forgotten this video. After we got Sheena back into her property, the security guard come round to the house and we got the video footage of him breaking the chain and Sheena, that's John's chain and John's padlock, breaking the chain and padlock to get into the property, onto the driveway. In the other videos we called the police turned up and they said it was a civil matter. John's filed a crime report for the trespass, aggravated trespass, because he wouldn't get off. We've got a CAD number, got a crime report number. Police won't even investigate it, they won't even release the report. So it just goes to show, how can I be done for criminal damage, yet the security guard doesn't, who's literally there with the police caught into the act. It's all fun and games, but still winning. When you stand on the truth, you can't be moved. And that's it. Everything comes out in the wash. And that's over and out from me today. Take care. Bye bye.